A unanimous Supreme Court decision on March 9 has settled the question of law whether or not presiding Deputy Speaker of Parliament has a voting right and can be counted for purposes of quorum in the House. The court ruled without any dissent that a presiding Deputy Speaker can be counted to form a quorum and can vote in decision-making. The ruling comes as a vindication for First Deputy Speaker of Parliament and Member of Parliament for Bekwai, Joe Osei-Wusu, whose actions have triggered this constitutional interpretation.
It was a voice vote, and I did not participate in the voice vote. But I insisted that I be counted as a Member of Parliament present to constitute the quorum before a decision was taken. Indeed, this decision affirms that position that I took. I find that very refreshing.
Recall the First Deputy Speaker on November 30, 2021, presided over the business of the House and counted himself to make up the numbers needed for a quorum and sought the passage of the initially rejected 2022 budget without the minority. While this triggered an application by private legal practitioner Justice Abdullahi, who sought interpretation of portions of the 1992 Constitution and prayed the Apex Court to declare as unconstitutional the First Deputy Speaker's conduct. The court in its interpretation ruled to the effect that 1. A Deputy Speaker is entitled to be counted for purposes of forming a quorum. 2. A Deputy Speaker or any other member presiding is entitled to vote for the purposes of decision-making. 3. Order 1093 of the Parliament's Standing Orders is unconstitutional, hence expunged. 4. The passage of 2022 budget on November 30, 2021 was constitutional.
It is there for anybody who wants to see. In Articles 102, Articles 104 of the Constitution makes it absolutely clear in black and white that the deputy speakers, I'm not speaking of the speaker, I mean the deputy speakers, when they're presiding, have the right to participate in the vote of the Parliament.
The minority in Parliament did not take lightly to the ruling. Minority Leader Haruna Idrisu suspects a sinister move.
Our attention has been drawn to a very disappointing ruling of the Supreme Court of Ghana, which more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions. To put it aptly, this ruling is judicial support for e-levy, nothing more.
Member of Parliament for Ningo Pram Sam George insists Parliament is a master of its own procedure and will not countenance any interference.
A chairman of a committee in Parliament does not have a casting an original vote. So why are they not saying that that is also a deprivation of his constituents? I mean, we pray the Lord justices. Their role is to bring clarity, but not rather lead us into confusion and obfuscate what the facts are. The law is clear. We have heard them, they've passed their ruling, but Parliament, we are masters of our own procedure.
Former President and NDC flag bearer in the 2020 elections, John Dramani Mahama, is simply shocked at the ruling as he writes on social media, quote, a unanimous 7-0, shocking but not surprising. An unfortunate interpretation for convenience that sets a dangerous precedent of judicial interference in parliamentary procedure for the future, unquote. Former Minister of Justice and Attorney General Ayikwe Otu, however, disagrees that the ruling amounts to parliamentary interference. In an interview on 3FM's First Take, he said, quote, there's no other law in the country which is superior to the Constitution. So whether members of Parliament are masters of their own rules, all their rules should not be above the Constitution, unquote. While there are split opinions over the ruling, and until such a time when the plaintiff, Justice Abdullahi, seeks a review of the ruling, which he said is likely, it is now law that a presiding deputy speaker has a voting right.
For a person to be a referee and a player at the same time, that part I cannot accept it. Which is why I'm saying that if on Friday, that's tomorrow, we're able to get a decision, I would explore every available means to have the Supreme Court relook at those sections of the decision that I disagree with.
It remains a point of interest how the Parliament of Ghana will cope with the court's declaration, which surely will change the order of things in the House.